Hello viewers, in this lecture I will talk to you about the last flaw in the consent, that is mistake. Mistake is defined in section 20 of the Contract Act. I will first read the definition and then will proceed further. Where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement, the agreement is void. Full stop. Explanation. An erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of fact. Full stop. Friends, pausing here for a moment. A very common word, mistake. And we in common parlance very casually use the word mistake. It is the same thing in law? The answer is clearly no. Look at the beginning part of section 20. Where both the parties to an agreement. So it categorizes what sort of mistake? When parties to agreement, so it must be between the parties, not strangers, not others, and both the parties. So, bilateral mistake. When both the parties to the contract are under a mistake, I'll explain how it can happen. Law says it can be a mistake provided it satisfies the other requirements of the section. What are other requirements of the section? Read further. As to a matter of fact, again, it must be a matter of fact, not law. In other words, you can very well say that mistake of law is no ground. You must be knowing a very celebrated saying in law, ignorantia lex non excusat, meaning thereby ignorance of law is no excuse. You can never say that I was not aware of this law. Simple illustration, an illiterate man committing murder, when being tried, will say that, sir, I have never gone to school. I never know that there is anything like IPC, Indian Penal Code. And I never knew that it is an offense. Therefore, don't try me, don't convict me, don't punish me. If at all civilization has to go on, you must know law. Whether you are literate or illiterate or highly educated, your station in your life is wholly irrelevant for the purpose of administration of law, in the sense that no one can ever say that I never knew this law. And therefore, mistake of law is never considered a mistake. Section 20 therefore categorically says that it must be a matter of fact. Say you are going to sell about immovable property. The factual aspects are where it is, what is its condition, who are the owners, whether there are any encumbrances or not, are there tenants, etc. These are the matters of fact. Again, which type of facts? Is it all types of facts? In the same example, who are your neighbors? What are they doing? Essential to the agreement. Facts which are essential to the agreement. Who are neighbors? What are they doing? Is never essential for the agreement to sell the movable property. Essential may be whether it is mortgaged or not, whether you have a right to sell or not. So, 4 different aspects: mutual mistake, both the parties to an agreement are under a mistake as to matter of fact, essential to the agreement, then only agreement is void. Mind well. In earlier 4 flaws, agreement is voidable. Here it is void. Why? It's difficult to guess. But the answer is, when there is bilateral mistake, there is absence of very important element, and that is consensus ad idem, meeting of the minds in the same sense is absent. Because both the parties are under a mistake. Take the example. There is an agreement to sell the horse. When the agreement is being entered into, none of the parties know that the horse is dead. Can it be performed? The answer is clearly no. It is neither fraud nor misrepresentation, nor coercion, nor undue influence. Both the parties were well versed, were informed, were under the impression that the horse is there. Maybe communication gap that the death of horse is not intimated, but the fact remains that when the parties enter into contract, none of the parties had a knowledge that the horse is dead. Obviously, there is loss of subject matter of contract. Friends, mind well, this is different than what we'll later on see, frustration of contract. Because in frustration of contract, the facts would be slightly different in the sense that when the contract is entered into, the subject matter of contract is in existence. It is because of some supervening impossibility, the happening of some event, that the performance becomes impossible. Therefore, what is contemplated under section 56 of the Contract Act and what section 20 says about mistake are quite different. Explanation again categorically says, and this could be quite common and more so in our country, if you have little knowledge about transfers or immovable properties. The poor illiterate farmer, I don't know how he can be termed so, when he takes money and agrees to sell the same property to 3, 4, 5 persons. And with each one there is higher price. And ultimately who suffers? It is those 2, 3, 4, 5 buyers who have to fight internship for getting the property. The poor illiterate farmer has to lose nothing because he has to give land only once. Contemplating this situation, because we have a tendency to go back because of change in price, and prices always go on a higher side. So explanation says that erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of fact. I cannot go back by saying that I had the impression that this property would fetch only 1,000 rupees, whereas now it is fetching 10,000 rupees. Therefore, I want to avoid there is mistake as to material fact, change of value of 9,000 rupees. No. Law says you cannot go zigzag. Whatever you have agreed, you have to go on with it. Mistake that is contemplated in section 20 is bilateral mistake. Unilateral mistake is no mistake. An erroneous opinion again is not a part of mistake. Now section 21 says what would be the effect of mistake of law. Section 21 says, I'll read first the section. The contract is not voidable because it was caused by a mistake as to any law in force in India. Semicolon. But a mistake as to a law not in force in India has the same effect as a mistake of fact. Full stop. Friends, what I have told you earlier about mistake of law. Section 21 categorically says that a contract is not voidable because it is caused by mistake as to law. Mistake of law, and when we say mistake of law of India, in force in India. And the second part is that when it is relating to foreign law not in force in India. Say in case of minor, I have told you earlier that it is voidable in England and it is void ab initio in India. In such situation, section 21 says that mistake of foreign law is to be treated like mistake of fact. Meaning thereby, the earlier section 20, relating to mistake of fact, would be applicable to foreign law. So mistake of Indian law is no mistake and it doesn't render the contract voidable. Mistake of foreign law is treated like mistake of fact. It has to be treated in section 20, and if all the ingredients of section 20 are established, in that situation the contract would be void, because it is to be treated as mistake of fact. Section 22, again I'll read first section 22. A contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. Full stop. Whatever I have told you earlier, unilateral mistake is no mistake in law. In order to treat the agreement as void, it must be a bilateral mistake. And bilateral mistake also of a material fact and fact only, not of law. And then only it would become void, not otherwise. Therefore, if there is unilateral mistake, I had understood this sense in this sense, law says it is your problem. Unilateral mistake is no mistake for our purposes. Thank you. The next lecture we will talk about very important aspect, consideration. Thank you.